This is our seventh seminar of the Health Law Seminar Series. On souhaite la bienvenue à nos collègues de Québec. Et je suis très content qu'on a Catherine Regis, qui est un ancien de l'Université de Toronto, et professeur Bernier, Louise Bernier, qui a fait son doctorat à McGill. So I'm very proud of having both an SGD student from here and a colleague from who did their doctorate at McGill University. I'll briefly introduce the speakers. We actually have also somebody who you may not see. I think we kind of have difficulties of portraying him on the screen, but you'll hear him in the commentary. Harvey Skepper. Then we'll have a presentation by our two presenters, short commentary by Harvey Skepper, and then we'll open it up for questions. So let me quickly introduce Professor Regis and Professor Bernier. Catherine Regis is an associate professor at the University of Montreal, Faculty of Law. She is the shareholder at the Canada Research Chair in Collaborative Culture in Health Law and Policy. She's also connected to the Centre de Recherche en Droit Public, where I've also spent some time many years ago. Before joining the University of Montreal, she was a professor at the University of Sherbrooke. She was also the director of the graduate program in Health Law and Policy there. She has a bachelor's in law from the University of Montreal, a master's in health law from Sherbrooke, a certificate in clinical ethics from the University of Geneva, and a doctorate in law from the University of Toronto. She's been a member also of the Barreau du Québec since 1999, is an accredited mediator, which I think in this area is particularly interesting and important. Has received numerous awards. She collaborates with a number of interdisciplinary and international research teams, particularly in medicine, management, and psychology. So her main areas of law are health law, policy, healthcare governance, prevention and conflict resolution, artificial intelligence, and international health, as well as behavior law and policy. So Professor Bernier is a health law professor and head of the Law and Health Science Group program at the Law Faculty of the University of Sherbrooke. She teaches individual rights, law and ethics in modern medicine and medical law, holds research grants from CIHR, Quebec Bar Association. Her current research projects are in the area of governance, related to ethics and health technology assessment, and in different approaches to autonomy in a medical setting, particularly organ transplants, beginning and end of life situations. She's a member of different ethics committees, and in addition to teaching at Sherbrooke, she has taught courses at the University of McGill, Faculty of Medicine, at the University of Nairobi, and also in Scotland. She has an LLB from Laval, LLM from Montreal, and as I already mentioned, a DCL from McGill University. So after that, we have Dr. Harvey Skepper, who is a partner of Million Skepper & Associates. He's nationally and internationally recognized as a clinician, health researcher, and innovator. He's professor of medicine at the University of Toronto, also an adjunct professor here at the Faculty of Law, where he teaches a course on biotechnology and law. He has held several executive positions, has been a vice president of MDS, has been a professor of medicine and oncology at the University of Manitoba Cancer Foundation. He has been the director of a World Health Organization Collaborating Center for Quality of Life in Cancer Care, and he has been an outspoken commentator in this area of debate, and has written several puppet pieces, and so is also with me on the Council of Canadian Academies expert panel on advanced directives, so directly related to this particular topic. So without further ado, I'll let our colleagues present, and then we'll go to Dr. Skepper and then to questions. So you have 30-40 minutes, and how much did you...
We'll adjust.
So if you go over time a little bit, it's fine. We have until about 2 o'clock, a little bit before.
Okay, perfect.
Okay.
Well, first of all, thank you so much, Trudeau, for the invitation. We're very happy to be here, Louise and I. Trudeau is a very special person. He's the best you can find, among the best you can find in this academic world is very, either on the intellectual level but also on the personal level. So it's very nice to be here, and I thank you very much for the invitation. Also want to say that we're going to have a very detailed PowerPoint, so if the students need that for your papers, we'll be happy to share the PowerPoint with you. So, you want to say something else? No, it's fine? Okay.
So, hi, thank you for being here. Our talk today is based on a French paper we published a year ago. And you received another paper as well, I guess, an English one. The focus is on the new regime that we have for advanced medical directives in Quebec. That's been there for a little bit more than 2 years now. And we will ask what is the value of this new regime 2 years after it's been established, and how can it be improved? What are the different flaws we see with the regime? There's advanced medical aid in dying is not possible right now through the advanced medical directives. We're not asking the question here. The talk is not about whether it would be a good thing or not to include medical aid in dying in advanced medical directives, but we will assess the regime, and I guess we will talk about the lessons that should be learned from the regime if it were to be included in the regime. What would be relevant to remember if we include it at some point. So we divided the talk in two different main parts: the legal flaws with the regime, and then the ethical limits we see with how the regime is built. So that's the and for now we'll give a little bit of context before we start. So the regime was established with the Act Respecting End of Life Care, like I was saying, in December 2015. And in this act, there were three different main focus. Advanced medical aid in dying, establishing medical aid in dying as a care, improving palliative care, and also establishing legally binding advanced medical directives. So how does it work? For now, you have two different ways of, two procedures you can use to register advanced medical directives. One is through a notary, so you consult with the notary and you fill out the directives. But the procedures that's used by 75% of Québécois is the filling out the form with the RAMQ, which is the public health insurer in Quebec, and then sending the form back to the RAMQ, so it's put in the registry, and then give the form to health professional family members. And in case of incapacity, if you have advanced medical directives, they are legally binding, so it's the equivalent to consent to care. Same weight as wishes expressed by a person capable of giving consent to care. So the RAMQ came up. In the law, there were not any limits to situation or care, but the RAMQ came up with a form limiting the enforcement of AMDs to 3 clinical situations. So you can fill out some advanced medical directives for if you are in end-of-life situation, so serious incurable condition, or situations where your cognitive functions are severely or irreversibly compromised, either irreversible coma, permanent vegetative state, or severe dementia. So it's limited to those 3 situations, and you also have 5 forms of care that you can ask or refuse in advance. So it's cardio resuscitation, ventilation, breathing, ventilator breathing, dialysis, forced or artificial feeding, and forced or artificial hydration. Okay, so this is also, I thought it was, so this is an example of the form, and it's checkbox. So you have a first situation and you have the 5 forms of care, and you either consent or refuse in advance. Okay?
So, I think we mentioned at the beginning that it's not allowed for medical aid in dying right now to do your advance directives. But as you probably know, there's been a recommendation given to the federal government to that extent in order to eventually allow ADMs for MAID. And but we know that it's also permitted in other countries such as Belgium, Holland, Luxembourg, and but it's not permitted. So it's certainly something that we need to consider and think about. But it is also part of a global trend in favor of allowing individuals to fully implement their autonomy. Autonomy is really at the heart of such regime, and further discussion about MAID. And it's also about respecting individual choices, even when people cannot express them anymore. So ADM, at the end of the day, are a tool to help decision making through complex clinical situations where communication with patients and their families can be challenging. Yet, as we will see, there are legal and ethical weaknesses with the Quebec ADM regime right now. At least this is what we're going to talk about. And we think it needs to be considered before we move forward in that direction.
So there are 3 different, in the legal flaws, that's the first part. And the first one is the illusion, the legal regime is built, we believe, on an illusion of an informed consent, okay? So there are 3 points with this. There are some, when you take the form and you look at it, you'll see that there are some problems with the wording. So informed consent process requires prior information from health professionals to be shared on the proposed treatment, for example, associated risks, answers to questions, alternative treatments in a clinical setting. And so patient can understand the nature of what is proposed and discuss and understand the options they are given. On the form, we identified a first problem with the wording that is used that can be very confusing. They talk about the form that people will download from the RAMQ system website, talk about medically appropriate care. So they talk about, they say that there's a disclaimer at the beginning saying you cannot ask for anything that is not medically appropriate. Okay, it will not be provided to you if it's not medically appropriate. And then we talk about medically indicated. Okay, a little later we say the form just refers to medically indicated care that could be proposed to you. And then later on it says in section 2, these clinical situations are increasingly common and are situations in which the relevance of certain care may be questioned, even in the case where it's required to sustain life. So we make a difference between relevance of care, appropriateness, care that is indicated indifferently all through the form, which is at best confusing, of course, when you read it. And we believe it could trigger some impracticable expectation and even deception once we approach it in a real medical setting. The form is built on an idea, and the regime was built on an idea that we thought that patient would, the purpose was that they were going to use it to refuse care, okay, in advance. So to avoid futility, and the need for this was based on that. But we gave them an option to accept care also in advance, okay? And so the fact that they can accept care in advance that might not be relevant or might not be offered to them by professional because it's not indicated or it's not appropriate or it's not, professionals are bound by their code of ethics, And Section 50 in the Code of Ethics of Physicians says that a physician must only provide care or issue a prescription when these are medically necessary. So the fact that we are consenting in advance to care could trigger a feeling that we have already decided, even if it will not be proposed to you at the end of the day, because it's not something that can be done in this particular setting. So the fact that it's not explained is a first problem. It can create confusion and expectation if you accept care in advance. Also, the choices that you make here are not remain abstract, as any consent you make prior to advanced consent. There's a sense that it is disconnected from the reality. This is not something new with this regime. However, the medical knowledge, we know that medical knowledge could change over time, could evolve depending on life experience of experiencing suffering, hope, socioeconomic situation. And there are some data saying that someone's preference are more stable when they fill out a form like that, when they are already sick, knowing what they are going through. Then the stability of preference have not been the same when you fill it out and you're perfectly healthy and you need to change it after. The problem with this system is not, it's the fact that it's hard to change. There's a procedure. If you want to change it, you have to fill out another form to revoke what has been filed, and you have to take it out and then file another form. So it's hard to do. And after 2 years, there's been 20,000 people using the system already, and just 5 revoked their advanced medical directive. We don't know if it's because it's been very short, it's been just 2 years, but there's just 5 over 20,000 who use this possibility. And once you fill them, they are good for, there's no limit of time. You can file your advanced medical directive and you don't have to go back and decide if you agree with it after 5 years or 10 years. There's no limit for now. So this is another problem we identified with the regime. Another big problem is there's a presumption of information. When you fill out the form, you are presumed to, you say that you recognize that this is binding, but at the same time, Section 59 of the law says that the author of advanced medical directives is presumed to have been in the possession of information needed to make an informed decision when he signs this. The problem with that is that there's no resources that are, it's a legal artifice which transfers the medical duty to inform, normally supported by healthcare professionals who have expertise, who have knowledge, onto the shoulders of patients. Oops, what? Excuse. Okay, no. And it creates a responsibility on the part of the patient to search and find the information they need to understand the nature of available options and to explain complex medical information. For example, you can refuse a nutrition hydration in advance when you will suffer from severe dementia. What it doesn't explain, and what you would need to understand, is that refusing such care will probably induce suffering that will require that you get some palliative care, and that might be hard to implement also once you are suffering from severe dementia. As you, I guess Professor Dresser was here, I guess, and she explains it very well in a paper. So this is a problem, and this presumption of information is also a problem because it says, it refers to a website, and it says if you need some assistance, go see a health professional or call us on the RAMQ. At the RAMQ, we'll give you information. And I've tried many times to call and to get information just for the research, and I could never get someone to answer my questions or just the line. It was difficult to get a hold of someone, to talk to someone. And even when there was no health professional who can explain different options or what I was consenting to, or, you know, so, and to go to a CLSC, to have someone, a clinic, to have a local clinic, sorry, to have someone explain, it's impossible to get an appointment for this. So there's no resources that are planned to address this, and it evacuates the role of physicians in healthcare decision, and it places patients' individual autonomy at the center of the process, saying, oh, you're in charge of it, and you're presumed to have, you know, find the information, but it doesn't assess for the need for protection and support that patients would have with the complex nature of the knowledge, the vulnerability and isolation of some patient, and other social and socio-economic conditions that we'll get to in the second part of the talk. So this is symptomatic of a tendency to reject medical paternalism and say you're in charge now, but we believe it shouldn't overshadow the duty of beneficence and benevolence and the duty of information that is assigned to medical okay, excuse me. And the third thing that I wanted to address is the free and informed consent that is seen more as a moment where you have your form, you didn't meet anyone, you just have to have two witnesses, you know, with you when you sign. You don't have to show them what you wrote or what you decided, but you just need to sign in front of them. So the consent process is more like a signature and ticking boxes than a real process. Okay, and we think it's a problem when you are facing such important decisions. And it must meet certain conditions to have value and effect if we want it to have some effect. And there was a conscious decision that was made with the regime. When you go back and see the parliamentary debates, you see that they didn't want to impose anything, any consults with medical staff. They wanted to be simple, easy to use, really to empower patients with their end-of-life decision making. However, I guess we oversimplified the process along the way, and we are missing some of its essence. So we are very far from a shared decision-making model that we believe that should, that it should involve a dialogue. Yeah, it will take more time, it will take resources, but if we don't do it, this is pretty, it could be an empty, close to an empty process. The last point, if we were to go through and include medical aid in dying, we already have this obligation to have a conversation. Of course, when we ask for medical aid in dying and we are competent, there's a legal obligation to have various talks with doctors, with family members if we wish to, and there's no way we could include medical aid in dying in such a process where you don't meet anyone and you don't have any conversation. So a few options to explore on the legal side. Even it's going to be a lot more complex than that, but if we were to keep that, we should change the language. We should use words that mean something and explain those words. We should drop the presumption of information. We should develop tools, interactive tools to measure the understanding and offer real online and face-to-face and phone assistance. Of course, this is the basic where we should, if we want to stick with that, we should at least do this. But yeah, I think it's a lot more complex than that, and Catherine will continue.
Okay, so on top of these legal issues, I think there's also ethical issues that comes with the actual, the current AMD regime in Quebec. So, and most of it are due to its extreme simplicity. So like you showed you at the beginning, it's just boxes that you tick, so it's very simple, no other space to write anything else. So at the end of the day, it limits the capacity to recognize a relational autonomy perspective, which is and a perspective that is sensitive to the social, cultural, economic, and political context in which a person evolves. I'll come back to that later on. But also, we think that most of this choice that was made with the regime is based on this somehow postulate that perhaps such decisions are in fact simple. So, and that you can see when you look at the parliamentary debates. It's a point that comes back that this is simple, so this simple decisions. We don't need to make any fuss about it. So, I would challenge you on that. I know it's debatable, but can we accept that such decisions are somehow ordinary decisions, despite the fact that it can accelerate death, or it can include very intrusive medical care. So first point is, I think we think that we need to have a more holistic understanding of the notion of autonomy. And just a minute, good, okay. So a regime like that is often based on the need to have a uniform and generalizable law that will apply to everyone. But what we see is, in particular cases, it becomes problematic. So it can be difficult with a general law to address polymorphic reality of the situation that can influence people's decision. So patient, and I would say lay people more broadly, are often treated as a general group, interchangeable, ignoring significant differences that can exist between them. So at the end of the day, it limits the capacity of the law to fully grasp the reality of human decision making. It's often divided on binary axes like competent, not competent, valuable, consent of care, not valuable, so very binary axes. But the nuances, like the 50 Shades of Grey that we have between that, it can be difficult to pinpoint. So at the end of the day, it can lead to a legally valid situation, but that can be problematic on an ethical ground. So just to bring forward, to open a window on the complexity that the regime is not necessarily able to address, let's take this situation, this example of Fiona, who is 70 years old. She signed her AMDs while still fully fit and healthy. She indicated in her form that she does not want to receive any life support, so she ticked no to all the boxes. And 5 years later, she has an accident and she's in a permanent vegetative, I hate the word by the way, state. So the physician uses her ADMs, no life support. Basically, that's exactly the kind of situation that the regime is aiming at. No problem there. But now let's add another layer of complexity to this situation and see where the decision was made from. So, two scenarios on additional circumstances in which Fiona might have signed her directives. Scenario one, she's been a victim of abuse by her family for many years. She's afraid to be maintained in a vegetative state where other types of abuse could be made. And for her, her AMD was one of the only way she could exercise power over her life. Scenario two. Fiona signed because she has a very negative image that she integrated the negative images that are sometimes conveyed about elderly in society. And she also is very fearful of living in a long-term care institution, considering all the bad living conditions that she's been transmitted by the news, for instance. And so she decided to choose option that would accelerate her death. So now let's add another other information, but now at the time where the doctor has to use her ADMs. Another scenario. So Fiona's son is in London at the moment of her death. The son asked the doctor if he could keep his mother artificially alive for a week in order for him to make travel arrangement and see his mother as his bedside. So he says that it's an important step for his mourning, and her mother would have wished for the respect of this will. So the physician is very torn by this request because he's not allowed to do it based on the form, but he totally understands the need for it. So what we can see is that the form first does not allow to underscore any form of oppression that can be at the root of the decision, and also or part of it, and also doesn't allow any flexibility to adapt to certain circumstances. So the questions that are interesting and that at the end of the day are of interest for relational autonomy is what are the reflections, the values, the certainties, the dilemmas, the hesitation that lead to a person's choice? What is the relational context of familial, economic, cultural, social situation that is specific to that person? And what role is this context playing in a person's decision-making process? So this is where we come to relational autonomy. So these are the kind of questions that it raises. Relational autonomy is mostly comes from the feminist critical movement. It implies that a person's autonomy is defined and will grow in a social context, and we're very embracing that context. And such context has a major influence on a person's opportunity to express her autonomy. It also invites us to an exercise of going deeper into the various constraints that can affect people's ability to make choices, and also to a certain extent help these people to make choices from the most autonomous starting point as possible. And then we need to think about what kind of means would be helpful in achieving such goal. So illustration of obstacle that can limit relational autonomy or full autonomy, it's oppression. And the two ex ante examples that I gave you were based on a form of oppression. So oppression may affect the ability to develop authentic autonomy. What we mean by authentic is the real capacity of making choice aligned with your values. And it also defines explicitly or even implicitly options available to groups or individuals. It can shape people's values and desire so as to limit their ability to make truly independent choices. So the example of oppressions that can exist, it's sexism, violence, ageism, but also how actual current political and social structures are defined. So example of that, the social context that glorifies youth can make people see aging or experience aging with aversion and fear, and also creating a distorted perception of seniors either by themselves or by others. Also, violence can limit people's capacity to develop the skills to exercise an autonomous choice due to a lack of opportunity to exercise choice in the past, by integrating a feeling of no social values or incompetence by lack of self-confidence. So self-confidence is a useful skill to have, or attribute, if I can say, to make a choice. So left in their usual environment or context, can these people exercise a real authentic autonomy choice? But also I want to say that the relational autonomy is very is sensitive to this broader context, but it doesn't see all the relation in a negative way. It also recognizes the importance of these relationships. It's all sometimes they can be positive or important influence on our judgment. So it recognizes the important role of our relational environments, or our relatives, parents, children, partners, but also healthcare professionals, how we can, in a dialogic process, build something together on a constant basis. So at the end of the day, these relationships can guide us in our reflection, or become guides in themselves in our decision-making process that will remain nevertheless autonomous. So I really like this quote from Walter and Ross. They say, to assume that an individual's interests are purely self-regarding denies the intimate web in which the interests of the other family members become part of her own interest, as well as the fact that she shares with these other family members some family goals which are not reducible to their individual goals. So knowing that the fact that the Form Act in its current form is not able at all to pinpoint these more complex layers of autonomy and choices, I think we need to adapt the regime to make sure that we are able, at least to a certain extent, to incorporate that complexity. So we have a two-step strategy to do that. I don't know if we can make the system perfect. I don't necessarily believe in perfect, but I believe in better. And this is what we're moving towards. So first one would be to improve the ADM form, the current ADM form. I will explain how. And then to offer an assisted communication option, space, or what we could call bioethical mediation. So first thing we could do to improve the form or the process right now is first to offer an opportunity to state, for people to state in a more explicit and meaningful way their preferences, their values relating to end-of-life care. So it could be a personal statement, it could be a reflective exercise. I know that other provinces have some kind of a reflective exercise integrated into the form, not to the extent that we would like to see, but still it's an interesting option. But also people could include, it exists I think for organ donations, a video file that could send to their family to explain what was in what state they were and what is important for them, or even to healthcare professionals. So there's an example that was given by, I don't know how to pronounce that, Louise? That person. For a French person, it's kind of weird. But anyway, so it says, and the full statement is very interesting, so it's shortened for this presentation, but it said, for instance, people could write something like more meaningful, like, my main goal is intellectual function. My secondary role is to avoid gratuitous suffering. If I can, with any degree of likelihood, even small, be returned to a state in which I can read, think, and write, I would be willing to take any risk to and undergo pain. In other words, my core values include prolonging meaningful life, but not merely prolonging death. You could also write something about you want your kids or your grandkids to be able to visit you at your bedside, and you're willing to prolong, to receive certain cares for a period of time in order for them to make sure that you could be able to add something like that. So these are examples. We could explore many other options, and we would hope to completely remove the checklist. Mm-hmm. But if we were to keep it, at least we should include something like that. So the objective, time-wise, I'm not. So the objective of that addition would be to give a better understanding of the relational environment of the individual, to give some form of identity of this form. Like, you don't know anything about the person. It's just yes, no, boxes, that's it. So to kind of understand where she comes from, what's important for her. And also would allow people to kind of develop a reflective approach to their values to help them in selecting the best and more coherent option based hopefully on their values instead of form of oppressions like stereotypes and other. The fact that you need to think about it and why this is important for you, we think that it would help. And also authorize more flexibility in the expression of people's wishes, like the example I gave about prolonging for 2 or 3 weeks your life for kids to meet you. The second option that we propose is to offer what we could call a bioethical mediation, but it's mostly a space where you could communicate, help with a third person. So it would be, this space would allow you to have that reflective approach, an opportunity to think about what's important for you at the end of your life. The person that would help the process would think she needs to be competent, to have special skills for that. And that would allow people to explore their values and preferences in such a context that otherwise it can be difficult, because otherwise it can be difficult actually to identify, to confront, to express, and often we don't really go in depth about why we want to do this. So very go deep, at least to a certain extent, to help you develop your preferences if you need to. And also, you could even, if the person agrees, invite another person, people around you that are important for you, to explore these values that are important for your family members and see whether they are coherent with what you want, have that discussion. And also to, if you think that it's going to be a problem, to, at the time of your end of life, your family is not comfortable with your decision, it might be nice to have this process where we can discuss before it happens and help the people go through the process, which will be difficult. It could be, actually, it could be very relatively easily to implement. Biomedical mediation is an interdisciplinary skill. Social workers, nurses actually working in the system right now, even physician. I know a physician who is doing mediation. And also, these people could be trained to actually help people doing that. And also, and this is something, I don't know if you remember Trudeau, but when I was a doctoral student, something that was very important for me is to further develop all the ADR, all the conflict resolutions, options in the healthcare system. I think it's totally underdeveloped, and conflicts cost a lot of money and time and other impacts. So it would be nice to perhaps you have people that are dedicated to just helping in preventing and resolving conflict in healthcare. So such an option would help patients pinpoint their most important values and preferences. Also facilitate the translation of your value into a medical context, which is not necessarily easy to do, and help the person in some context to identify the positive and negative relational influences that can impact your decision. So that can be helpful to that goal as well. And this is the preventive support that I mentioned. So another quote that I thought was interesting is from Dresser. At times, work in bioethics conveys the impression that seriously ill patients and their families would be in good shape if clinicians would only do things like give patients proper information, respect patients' choices, and follow advanced directives. We can assure you that it is not true. So many things can come in between the process. That's why to increase the support, it sounds like a very interesting idea. And at the end of the day, we should invest in improving that process, because another quote I find interesting, but I think that this is true. Any society that is truly committed to promoting autonomy must work towards eliminating forces of oppression that reduces citizens' opportunity to become maximally autonomous. You want to go with the conclusion?
Oh, yeah. Well, we can go.
Okay.
But we identify legal and ethical considerations that were evacuated from the actual regime, and we explored avenues for improvement. So better consent, of course, to care process, inclusion of a reflective approach into the consent process, values, preferences, and assisted communication or biomedical options. I think the oversimplification is just not working. It's too complex, it's too important of a decision to make. So those are important decisions to make, and we cannot really simplify them and make them easy to do. It's not easy, and there's a lot of people that are involved. The current regime is to be used more as a model for allowing advanced consent. If we want it to be a model to eventually allow advanced consent to medical aid in dying, if it's where we want to go as a society, it's not, we're not sure, but if we go this way, we should really review and revise its legal and ethical flaws. They need to be remedied before. So thank you very much for your attention.
So we now will hear from a clinical perspective by Dr. Harvey Schipper, who joined us with saving us from his flu-related germs. Harvey.
Thanks very much, Trudeau. I would have, clearly had I come, I would have been sharing not just ideas, but some things somewhat less optimistic. So thank you for welcoming me in this electronic format. Firstly, let me ask if I can be heard at this point.
Yeah.
We okay?
Yeah.
Okay. So I want to commend both of you on a very provocative and I dare say brave paper, because implicit in it are very pointed questions about some of the ways we think about these issues in society currently. The reality is there's nothing new about assisted dying. The technology's not new. The debate has gone on since Socrates' time, if not before. And it comes and goes in cycles throughout history. What is somewhat different now is the role of the state. And to put it rather coarsely, what we're basically asking the state to do is provide the means for people to have their lives ended, largely at a point of their choosing at the moment in the context of some form of reasonably serious illness. And there are a number of bioethicists and actually theological scholars who have a very interesting concept called the fence within the fence that says there's some issues that you do not directly attack. You can attack peripherally, but if you directly attack them, you open a Pandora's box, which is considerably more complicated than you might have anticipated. And I think, without positing a religious persuasion to this, the whole notion of going to the position where you're suggesting to the state that it legally authorized the ending of a life punctures one of those boundaries, and this is why you find all of this debate going on. The provocative thing in your paper, and I resonate with it very much, is the notion of diminishing the role of physicians. And that also is a very old argument. Many years ago, I was asked to give one of those named lectures, and I put up a slide that said, that put within quotes the notion that these physicians are consuming resources and not paying attention to the broader concerns of the community and all of the rest, and we somehow have to provide some discipline about this. And in the audience were a couple of ministers of health, and I sort of turned to them and from the podium, and I said, who do you think said that? And they sort of both put up their hands, and then I pointed out it was Herodotus. So it's a very old issue, and one can build quite the case these days that the role of the physician is being diminished, in part because they're competing needs, the individual with the collective need as in state-provided healthcare systems. And there actually is some very interesting historical stuff from the beginnings of OHIP in Ontario, where a very detailed plan was made in the 70s to discredit physicians so that government could be seen as the virtuous provider of healthcare rather than these rapacious physicians who are only in it for money. So it's a concept that's out there. I don't think it fundamentally drives this, but it does sit there and is part of the broad social mix of why this is going on. The other thing that you spend a lot of time talking about, and again, which is fundamentally important, are the competing concepts of autonomy. To read the Carter decision, and even to read Regis before that, suggests that there's only one form of autonomy. Nobody's really thought of beyond that, and it's about the individual being completely autonomous in the sense their boundaries end at their skin. And we don't have to really take note of the broader concerns. Now, there are some people, I really do believe, having been at this game as a clinician for a while, where that's their view. It's all about me. I don't care about anything else. Nothing else matters. But the relational autonomy is a very broad concept, and it's a concept that good physicians are being taught about, and that is largely absent from the conversations about assisted dying at the moment, to the extent in some jurisdictions where they're saying the physician who knows the patient should not be involved in the conversation. Because after all, they'll bring their inherent biases and knowledges, and really this is about what the patient wants here and now. And it's really important, I think, that you continue to introduce that very important notion. Finally, in the specific examples you draw, you make the suggestion that we stand back. And I think that's vitally important. You may be aware that the federal government has announced at the end of December that they were going to be promulgating a series of guidelines for information collecting with relation to medical assistance in dying. And the nature of those questions is going to be absolutely fundamental to the success of our learning exercise. If all we do is tick off the boxes, yes, you spoke to 2 doctors, yes, you waited 10 days, yes, it seems the patient met these criteria, yes, I had a conversation, then we're not going to really get at what are the drivers, as you so ably point out, that lead people to come to these conclusions. Are they misunderstandings? Are they based on fear? What are they based on? And unless we have that kind of rich knowledge, that as we go forward, and particularly as we contemplate expanding the possibilities to mature minors and mental illness and advanced directives, unless we have that knowledge, we're not going to really know what we're talking about. And the medical analogy I draw is to say, hey, you know what? This is a new treatment. And like any new treatment, we are obligated clinically, biologically, morally, and socially to understand the impact of that treatment. We do that with new cancer drugs, we do it with new devices. Why aren't we doing this from the broad perspective you put forward for assisted dying? And from that perspective, when you then collect the data, you start to be able to answer the questions and find the right spot for this as one form of treatment. After all, I think most of us consider it a treatment of last resort. Some may not. But at least you want a database of why people are thinking that way. And certainly my clinical experience has been, a lot of it has to do with fear. A fair bit of it has to do with misunderstanding. For example, I've spoken with quite a number of people in a retirement home about this. And they say, hey, wait a minute, this new law gives me the right to decline aggressive therapy at my age. Well, of course, that's not what this law is about. That's been on the books for a very long time, as you point out. So there are elements of misunderstanding. So you are brave to take on the notion of influence of physicians. And your reference to McCullough's paper about the role of bioethicists is particularly brave and kind of fun. And let me end by trying to be at least half as provocative as you are, to paraphrase the first Prime Minister Trudeau, who once upon a time said the government has no business in the bedrooms of the nation. And one wonders, just to be provocative in this group, whether in fact government has any business at the bedside of the dying. And let me leave it at that for now.
Great, thank you, Harvey. So we'll open it up for questions now, as I've done in the last couple of sessions. I'll start with some of the questions that students had. So I have a question by Jennifer Crawford.
Hi, thank you for the presentation. I think my question was somewhat answered when you elaborated, but I was wondering in the context of medically assisted dying, how some of the proposals that call for a reflexive analysis could be implemented for patients suffering from an illness like multiple sclerosis, where the desire for medically assisted dying might be genuine and well-informed, but symptoms of their illness prevent them from engaging in this kind of analysis. Due to the rapid degeneration that occurs for patients like this, it's possible that they wouldn't be able to speak, let alone write down a personal statement.
Okay, so your question is about medical and dying, and in the context where people cannot really engage in the form of a...
But they are competent.
Pardon me?
Are they competent?
They are competent? You mean that they...
Well, to an extent, I mean, sometimes when people have multiple sclerosis, they can think, but they can't communicate.
Yeah. You mean that if we should extend medical aid in dying to them?
Well, it was in response to your proposals regarding advanced medical directives. And
Yeah.
so I think sometimes with multiple sclerosis, it would still be an advanced medical directive because it might not be that they want this to happen today,
Yeah.
but as they progress.
But if they're capable, I mean, the same reflection applies. I just want to mention that I read a very interesting article about using mediation in the context of people with advanced Alzheimer. And is that in English? Okay, so it was very interesting that this is something that intuitively you would say, we cannot really do mediation with someone who's not fully capable, and the result that he achieved was pretty impressive. So just to give them a little bit more autonomy, that they were very successful in doing that. So I think we could implement these other options as well to guide through the process. The trade-off is, and this is always a concern with people in the healthcare field, is, well, it takes time, right? They will always give you this answer. So this is why we need to think about why this is important. And when you go deeper into the literature about, like I mentioned, the cost of unresolved conflict, how it can affect the fact that you, someone close to you or yourself take a decision that is not fully aligned with your values, can the stress that you develop and the physical and mental impact it can have on you in the mid and long term are cost as well. So.
And for the people staying after also, and to just follow on that, you would have to have time, have resources to find a way to fully understand. You know, probably it's not easy to speak, but you know, you have to take the time and probably try to find someone who can help with writing, or you know, there's different ways of understanding. But yeah, you have to have the luxury of time and the resources to do it. But yeah, certainly. But it seems that we just evacuated all of this saying, it's easy now. You can do it online, have 2 witnesses, take anyone, you know, and just do it. But so I guess we would have to take another point of view, but it would certainly be a good thing on the long term. Also for, you know, for the resolution, because there's people who are going to be implementing this decision after, and not knowing if it's the right one can be very, very difficult. There's a lot of literature in this also.
So, Harvey, I may ask you from time to time, but if I forget, you can intervene. If you want to add something, you just speak loud.
Okay, thank you.
Okay. Okay, so I have Rosa Shan.
Hi. From reading your paper, like it's a brilliant paper, and it's really kind of hit home with me about kind of very simplified forms and the way you can kind of make quite a significant decision. But I was quite interested by your discussion of relational autonomy and specifically the kind of positive and negative aspects of that. And I was kind of wondering how you propose kind of practically you can balance that. So obviously there's the need to recognise that we need to kind of diminish the negative like societal influences, but then by bringing physicians and family members involved, there is the risk that they can go beyond just positive influence into becoming more the negative influences and kind of coercing the patient into a decision that they didn't ever want to make. specifically I think in the kind of medical assistance in dying context where the decisions are very significant, both if a patient chooses to continue living or to end their life.
But these influences are already there, right? We agree on that. This is a very interesting question, and we don't have the full answer to that, but the question of what is the normative impact of relational autonomy, and not only on that topic, but on consent to care more broadly, or on the law actually, like we discussed before, is a very interesting question. I think we will need to further research that. But I think mediation is certainly something that can help to, with a third person, external or somehow related, can help to pinpoint when it is a good time to embark these influences or not. I think that could be a good option. I just want to mention it a slightly different topic, but talking about bad influences, I didn't mention it, but I said what oppression can be a form of something that can influence relational autonomy. I didn't mention that abuse and violence towards senior is a real issue. It's not like something that happens from 1% of people of the senior. So it really is a big issue. There's data that proves it, at least in Quebec. I don't know for the rest of Canada. And we also just passed a law trying to help to improve the situation. So you just add another layer of there's a lot of abuse, and then we have a form, we adjusted the boxes. I mean, are we going to increase the abuse even further, or leave these people like on the side? So we absolutely need to have a form, not a form like that, but to have a broader discussion about our social responsibility, medical responsibility, family responsibility, at the same time that we discuss this.
And I guess that the process we will put in place would need to bring as many people as possible. It would not just be one person. Ideally, you would bring, because those influences are already there. So if they can be voiced, they can be heard by, even if it's just one family member, but the other family members can hear it, and they can address it with the person. Maybe it's safer this way, but you need, of course, money to put it into place and time, and to allow people to gather together. It's something that we didn't figure out how it would, but yeah, it's a good point.
Yeah, it's a sort of valid question.
So Valentina,
It's Harvey.
So much.
Oh yeah.
Harvey, you wanted to say something? Okay.
I'm having a little bit of trouble hearing, so I may not have picked up nuance of the question, but what I'd like to ask both of our speakers is, at the end of the day, who's going to be the most responsible person for ascertaining that, the complete job has been done, collecting that information on the patient's behalf? Who does that, and how is that communicated? Well, you've obviously laid out some principles, but at the coalface, how's it going to work?
If we go with assisted mediation, I think that the role of the mediator would be to, the person who will sign, who will go through the process, would be responsible for the decision. But I guess that if we want to have assisted mediation or assisted dialogue, I think a third party, a person, could be in charge of having everyone heard, I guess, every voice is heard. It's hard to identify someone who would be responsible for ensuring that everyone has been heard, I guess, but it would certainly be a step. The fact that it's done now with two witnesses who are not at all related to the person sometimes is certainly not a good way to do it. So, but to add someone else, a third party who would be independent, I guess, would be a good step. But
yeah, I think if I could add on that point is, I think the point of our talk was to show that this is a contextual response, actually. we cannot, this form says the person in every context will be the one who knows best what's best for her, knows all the information that she needs. So, and we're taking a step back saying, well, take a minute, think about it, not always. So kind of to respond to your point is, it is more than, it is contextual, and we need tools to go deeper and underscore these potential influences.
It has some, it may have some connection to the kind of model of trained end-of-life specialists that you have developed, particularly in the Netherlands. It's not exactly the same because they're more retouched, checking whether the conditions are fulfilled, but they do interact to kind of look at what is going on. Valentina, yes?
I'm just wondering if you can speak to any of the other advanced directive regimes that are in Canada, and if they're similar and different to Quebec's at all?
Well, you know, Quebec likes to do things differently, so we don't know much about the rest of Canada. Even like consent to care, I know it's different for us than it is for you. So
We came,
cannot answer that.
we looked at the Albertan one, the form that they have, and where they can really, really state like the statements we had. There's a lot of places for, you know, a space where you can have a personal statement. And there's a lot of questions, and it's a lot more detail. So we looked into this one, but we didn't do a full, full evaluation.
But that's not like for instance, I know Alberta has a form that is a bit more complete than ours, and they invite you to that reflective approach. Like, okay, so do you want to receive this care? What is important for you? What do you want for it? So they kind of invite you to reflect on what is important for you and whether this choice is related to that. So I think they go further.
In a form,
but
so
I won't say that we want to go even further.
Yeah. But if you want to stay with a form, they have a better form.
Yeah, for sure. I mean, how bad can it be?
No.
Okay, so if I forgot any students who send me a question, so just alert me. We'll continue. Patrick, yes? No, you didn't. Wayne, okay, next to.
I want to thank you for a really terrific talk. I thought your coverage of the complications and issues around AMDs was really, really terrific. It's been in the literature for a long time. Rebecca Bresser's been talking about this for a long time. I think the issues are important, and I thought many of the suggestions you had for improving the process, not only in Quebec, but elsewhere, are really terrific. I just wanted to ask you a hypothetical question. Your focus was on end-of-life care in general, not on medical assistance in dying in particular. But assume that we put in place a regime for AMDs in general for end-of-life care that you would find at least satisfactory, at least good enough, if not a gold standard, at least passes it surpasses the threshold. Medical assistance in dying doesn't seem to add any further problems. So I'm wondering if we had a regime in place that you found satisfactory, is there any reason not to extend it to MAID as well?
So your point is that it doesn't add any, it's not different than the other decisions.
The issues don't seem different in.
And why is that for you? Because it's debatable, isn't it?
Well, I mean, advanced directives, declining life-sustaining treatment will have the effect, if they can often, mostly will, usually will, have the effect, if they're honored, of accelerating the death of the patient. You're still making a life and death decision about yourself, about how your life, whether your life will be extended or not. MAID is a similar decision. You're making a decision about how your life might end. I don't see any issues in it that are different in kind. It's obviously a very serious decision you're making about your life, but then the others are equally serious. So I don't see a difference in kind between an advance request for medical assistance in dying and advance refusal of life-sustaining treatment. So if that's the case,
Yeah.
as it seems to me it is, if we have a regime that's adequate for these other cases, why isn't it adequate for MAID as well?
Yeah. You want to go
I can. Oh, anyway,
I would mostly agree with you actually, but what we see is that in the general population, that's not the feeling of. They draw a line between the two. There's a difference, and we see that just on a historical level. When you think about in Quebec, like the fact that you can choose to refuse care that would lead to your death, it's been there for 20 years.
It's widely accepted, right?
But we just recently, in the Carter case, and you know the story, but Quebec was even before that with its law and thinking about all these issues and medical and dying. So you see that it's a step that for people is, you kind of go in something that it's more sensitive. So on an individual perspective, you could say that. It would depend. I'm sure we wouldn't all agree on that in this room, but you can certainly see that in the population, the value about the difference between the two cares. It's mixed. So
Yeah, and you would have to be very precise on when, when is a good time to get medical aid in dying and in advance. And we know that Dresser was talking about it also, like it's hard with people with the dementia to sometimes to assess whether advanced medical directives are easy. It's not easy to implement with some kind of some populations, patient populations. So I guess there's some kind of I'm not sure we're there yet, because it's an action, a clear action that has to be made to induce on an incompetent patient. There's some discussions to have on this, of course, and I think we will get there probably, but it's mostly it's.
The word I was looking for is social acceptability.
Why c'est ça?
It makes a difference.
I would situate it different, that there is a difference, for example, with respect to the added component of bodily integrity. You refuse life-sustaining treatment. One of the reasons is autonomy. Another reason is also you don't invade people's bodily integrity. If you provide medical assistance in dying, you do exactly the opposite. So you invade the bodily integrity based on autonomy. And so is there no difference? I would say yes, there is.
Well,
In the practical implications as well. So
just to come back to the point that you were making about the issue about, in the case of, say, a patient with dementia, at what point would it be appropriate and so on. That's exactly the same issue we face if the patient is refused treatment. At what point do we discontinue treatment? At what point has the patient reached the stage that he or she anticipated in advance, and we now discontinue treatment? Again, I don't see it's any different if the question is whether we're administering MAID on the one hand or discontinuing any further life-sustaining treatment on the other. It's exactly the same problem. I mean, all of the debates that Rebecca Dresser kicked off for decades, they weren't about medical assistance in dying. They were all about withdrawal of treatment. Those problems are real, but they're problems that don't seem to me to apply any differently to administering MAID.
You can ask a physician, but many physicians, one of the big debates in the Netherlands. So psychiatrist Chabot will say, well, there is something special when you have to kill a person who doesn't know what's happening to him or her. So when you actively have to inject a person who may resist, he would say there is a difference with abstaining from treating that person when the person said that they didn't want to have treatment. So you can say philosophically it comes down to exactly the same, but the actions involved are different. But anyway,
and also just the wording here doesn't mean that you are discontinuing the treatment. Is that you're refusing that we start the treatment. So it's not really the same, I guess. You're not discontinuing. It's just I refuse to to receive it. So for me, it's different.
But, there's going to be a timing issue.
Okay.
here.
Yeah, of course, true.
Any other questions?
So my question is, I guess, possibly just linked to AMDs in general, that depending on how long they were arrived at in advance, being need to be invoked, oftentimes the wording's very difficult for them to be honored, and they're not at all. So my question is, can you speak to maybe about in the mediation portion, I know you said you'd like to see more fields where patients can write down exactly in which circumstances. You gave some examples of, you said intellectual capabilities are the #1 priority, and secondarily it's evasion of harm. So oftentimes I think it might be difficult for people to be able to express that or even not realize that those might be their priorities. So is that where the mediation component may come in helping them arrive at that? Or are there other services or ways of helping them? you think?
Totally. This is why we propose this option. It's very difficult to take a step back and really think about that. When do we have that kind of moment, right?
Yeah.
So it's very imponderable questions that we don't always ask. It would be a very nice addition to have someone that can help us to identify these. But I would say, if I want to go further, I would say if a person is incapable of having any reflective posture at any point, how can we accept that this document really express her true wishes, even at a time that we won't be, even after, when she won't be able to discuss that and we won't be able to question her about, is it what you really want? I mean, wow. If you're not able to do any reflection, some level of reflection, I kind of question the relevance of it. So.
The validity of the consent per se also. And of course, you could change your mind with experiential knowledge of your illness through time. And that's why we are thinking that we should review them and we should have the conversation not just one time, but a few times, because you could change your mind on the importance of reading or, as time goes, of course. But
what's the movie that you talked about that really illustrated that?
Oh yeah,
Still Alice. Have you seen that movie? Still Alice.
It's very good. We could talk. Yeah.
I just have a short. Is this mandatory or voluntary?
Oh, voluntary.
It's voluntary.
Well, once it's signed, it's mandatory.
So it's purely voluntary.
Oh yeah.
Okay, to
So
do it, yeah.
The question I would have then is, what justification would either or both of you have for the Quebec government, whose form this is, right, making it semi-mandatory under certain circumstances, or absolutely universally mandatory for all adults in Quebec, if they're competent, at least when they execute the AMD in advance, right? Advanced medical directive, right? So, what's your position on that?
The fact that the government didn't impose everyone to do their, it's a matter of autonomy, again, I guess. It would have been kind of contradictory to say this is to increase autonomy, but we force everyone to do it and through this form. I guess that was a step that would go overboard. But really, when you read the parliamentary debates, it really was to avoid, like the comment made before, I thought it was very interesting. It was the state who wanted to intervene with the postulate that physicians would go overboard in their care, right? And they say, so let's do this. People will say no to most of care, and we'll settle
family
the
members,
issue.
yeah,
Exactly.
who would want futile treatment to go on to be pursued.
So when you read about, you understand what was in their mind, and then it was that. Right?
The politics are quite obvious, but I'm talking about what you think about ethical, legal.
I would say autonomy is a
Person
major
position.
issue to go further on that.
And I don't think everyone is at their same point of reflection. We're not we're not ready both at the same time to think about those issues. Maybe that for now there's been only 20,000 Québécois who filed those advanced medical directives.
And there's also another option, you can also choose, you can do that, or you can choose to delegate the decision to someone else. So you have kind of a mix of options in Quebec.
Oh, yeah.
So you could decide, I don't want to do this myself, I totally trust Louise to decide what's good for me at that point, and we're gonna have that discussion. So there's mix of options. Yeah.
So I have two last questions, maybe briefly the two questions, one after the other, and then we'll let him answer. Okay. So the two questions will be asked, and then you can.
Okay.
Correct.
So I guess I have more of a practical question. I wonder, because since it's only been 2 years since the Quebec government's rolled it in, I'm not sure if this has ever come up yet, but what would happen in the case that a patient or a person completed an AMD, and then a couple of years later, during like a medical consult, they ended up having an advanced care planning discussion with the provider and had a different medical order that, and there's like a discrepancy in their preferences, understated.
Yeah.
So I guess like legally and ethically, which one would the provider have to follow?
Oh, the last one, it's in the law also. They
Okay.
will come back, if the person is still competent, they will ask if they would like to change that, and if they still believe it's a good, The problem is more when they're incompetent and there's no way to go.
So does that mean that, so I know you also said that it could be electronically filed?
You can do it, yeah.
Yeah, so does that mean all providers would be able to see that they haven't previously stated, like during every visit?
Yes.
Okay.
With respect to the idea of introducing mediation into this decision-making process for people who feel that they might need that, I can kind of see a scenario where, sorry, I'll rephrase. Do you think it would necessarily need to be a lawyer who fulfills that role?
No.
Okay, just because I can see a problem where there'd be like a burden to then pay.
No.
Yeah, I briefly mentioned that mediation is a very interdisciplinary function, at least in Quebec. I don't know other places, but it's in the law that other professionals can do mediation. There's architects who do mediation, so no.
And on the cost issue, I guess it would have to be thought about how we would pay for that and who would pay for that, because with the notary process, we saw that only 25% went to a notary and 75% went to the free way of doing it. So we should ensure that there's no cost barriers to that, of course.
Okay, on that note, please join me in thanking our presenters. Commentator Harvey in the back. Just a quick announcement. The next seminar is actually in 2 weeks. Y.Y. Chen, Assistant Professor, Faculty of Law, University of Toronto, also University of Ottawa, also a former student from here. We'll be talking about debating migrants' inclusion in healthcare solidarity. So please join us in 2 weeks. Thank you. Well, I have to, unfortunately, I have to present